Welcome back to the deep dive. Today, we are tackling a nightmare scenario. It's something that every parent fears, but we're going to look at it from a legal angle that is absolutely critical.
It really is. For anyone in education, policy, or frankly, anyone who just cares about protecting kids.
Imagine this. You send your child to school. You trust the system. You trust the building. But then the unthinkable happens. Your child is harmed, abused by a teacher.
Which is horrific enough on its own.
Exactly. But then you find out that the principal or the superintendent, maybe even other teachers, they saw red flags. They saw things that looked wrong, and they did nothing.
It is the ultimate betrayal of trust. And it raises a massive legal question. Can you sue those bystanders? We aren't talking about the abuser here. We know they're liable.
They committed the crime.
We're asking about the non-abusing employees.
Yeah.
Do they have a legal obligation to step in?
That's the question. We are diving into Marquay v. Eno. This is a landmark New Hampshire Supreme Court case from 1995 that really rips open the question of duty. It forces us to ask, does every single person with a school badge have a legal duty to stop abuse they know about?
Or is that duty limited to just specific people in the building?
Exactly.
It's a complex issue because it clashes with some very old, very fundamental rules of common law. To understand Marquay, we have to map out a specific path.
Okay.
First, we need to understand the special relationship doctrine. That's the foundation. Without that, there is no case. Second, we have to look at the supervisory test, which is what distinguishes which employees are actually on the hook.
So, does the janitor have the same duty as the vice principal?
Precisely. And third, we have to analyze the scope of that liability, especially when we talk about things like off-campus injuries and foreseeability.
Okay, let's unpack this. Before we get into the specifics of the case, we need to set the stage with the basics, because I think most people have a misconception about how the law works here. If I'm walking down the street and I see someone in trouble, let's say I see a blind man about to walk into traffic, what does the law say I have to do?
Generally speaking, nothing.
Nothing. I can just watch.
That is the black-letter law. As a general rule, a person has no affirmative duty to aid or protect another person. You could sit on a park bench and watch a stranger walk right into an open manhole, and legally, in most jurisdictions, you don't have a duty to stop them.
That feels incredibly wrong. Morally, that feels bankrupt. Why would the law be set up that way?
It does feel wrong, but the legal reasoning is actually quite deep. It goes back to the concept of individual liberty. The common law has always been very hesitant to force people to act.
A slippery slope argument?
Sort of. If the state forces you to rescue someone, where does it stop? Do you have to donate a kidney? Do you have to run into a burning building? The courts have historically said, we will punish you for hurting people, but we generally won't punish you for failing to be a hero.
Okay, I get the logic, even if I don't like it. But obviously, there are exceptions, right? Parents have to save their kids.
Exactly. And that is the massive exception. A duty to protect arises only if a special relationship exists between the parties. Parents and children, jailers and prisoners, hospitals and patients.
And that is the pivot point for today. The question becomes, does a school have that special relationship with a student? Is a school just a building, or is it a parent substitute?
And to answer that, we turn to the case.
Let's look at the source material. We're going to test this rule against Marquay v. Eno.
This is the perfect case to break this down because the court is very methodical. They don't just wave a magic wand. They look at the mechanics of the relationship.
Let's analyze Marquay v. Eno. We need to start with the people involved. What are the legally dispositive facts here? Who are we talking about?
The facts are tragic, and honestly, they're hard to read. The plaintiffs were 3 former students: Lisa Burns, Jennifer Snyder, and Yvonne Marquay.
And their allegations.
They brought allegations that they were exploited, harassed, and sexually abused by certain school employees, specifically teachers and coaches named Michael Eno, Brian Erskine, and Brian Adams.
And this wasn't a one-time incident, right? We're not talking about a single bad day.
No. The timeline is significant. The abuse allegedly started as early as the 7th grade for Snyder and Marquay. For some of them, it continued all the way through high school and even past graduation.
So years.
We are talking about long-term grooming and abuse that spanned arguably the most vulnerable years of their lives.
And who are they suing? Obviously the abusers, but they're going after others too.
That is the key. They are suing the non-abusing employees. This includes superintendents, principals, secretaries, and other teachers.
The ones who stood by.
The allegation is that these people knew or should have known about the abuse and failed to act. The plaintiffs are effectively saying, you watched this happen for years and you did nothing.
Okay, but what about the location? Did it happen at school?
And that's a crucial gap in the facts that the court had to deal with. The complaints didn't specify if the actual sexual contact happened strictly on school grounds or during school hours.
So we have students suing the staff who stayed silent. And what was the core legal issue the court had to decide?
The issue is this. Do school district employees have a common law duty to protect students whom they know or should know are being sexually abused by another school employee?
It seems like the answer should be an obvious yes. If you work at a school, protect the kids. But as we established, the general rule is no duty to rescue.
Right.
So how did the court build a bridge here? What rule of law did they apply? And I don't just mean they used a precedent. How did they break it down?
The court looked to the restatement of torts, specifically sections 314A and 320. They essentially constructed a rule with 4 distinct elements that have to be met for liability to stick.
Okay, what's the first one?
Element 1 is the special relationship, which is effectively defined by custody. A duty exists because schools take custody of children, depriving them of their normal parental protection.
Okay, makes sense. What's 2?
Element 2 is supervisory responsibility. The duty doesn't apply to everyone in the building. It applies only to employees with specific supervisory authority, those acting as parental proxies.
Ah, so not the janitor.
We'll get to that.
Yeah.
Element 3 is foreseeability and knowledge. The defendant must have actual knowledge of the abuse or knowledge of facts that would lead a reasonable person to suspect abuse.
And the last one?
And element 4 is proximate cause and scope. The breach of supervision must be the proximate cause of the injury, and this applies even if the injury ultimately happens off campus.
Okay, that is a lot of moving parts. I want to walk through this slowly, piece by piece, because this is where the logic really gets tested. Let's look at the court's elemental analysis.
Let's do it.
Start with that first element, the special relationship. How did the court justify that schools are special?
The court relied on restatement section 320. The sub-rule there is basically one who takes custody of a child is required to give them protection.
And applying that.
When applying this to the facts, the court found that schools absolutely share this special relationship, and they cited 3 main reasons. First, and most importantly, compulsory attendance laws.
Kids have to be there.
Exactly. They don't have a choice. If you force a child to be in a building, you are stripping them of their parents' protection. You can't strip that protection without replacing it.
And the other 2 reasons.
Second, parents have an expectation and reliance that the school will keep their kids safe. And third, they cited the social importance of education.
So the conclusion for that element was pretty clear.
It was. This relationship outweighs the interest of immunizing the defendants. A duty of reasonable supervision exists because the school has taken custody of the child.
That makes sense. It's almost like a prison or a hospital in that sense. If the state says you must be here, the state is responsible for what happens to you while you're there. Understood.
Right.
Now, let's move to the second element, supervisory responsibility. This is where I struggle a bit. Does this apply to everyone with a paycheck? Does the groundskeeper have a legal duty to intervene if he sees something?
This is where it gets really interesting and where the court had to draw a hard line. The court explicitly rejected the argument that all employees have this duty simply because they get a check from the district.
So what's the rule then?
The rule here is that the duty falls only on those who act as parental proxies.
Parental proxies.
In applying this, the court distinguished between roles. A secretary, a janitor, or a cafeteria worker typically doesn't have supervisory responsibility over a student's education or daily life. They aren't standing in for the parent in the same way.
So generally, no duty for them. Wait, hold on. You're telling me a janitor can look a kid in the eye, see them in danger, see a teacher hurting them, and walk away scot-free?
Morally. It might be repugnant, but legally,
Yeah.
yes. The court says their job is to clean the floors, not raise the child. They haven't been given the authority or the responsibility of a parent.
That sounds insane.
However, this is vital, the court made a special application for principals and superintendents. Even though a superintendent rarely supervises a specific student in a classroom, they oversee the entire operation.
They're in charge of the whole system.
Exactly. They are charged with the general welfare of the institution.
Mm-hmm.
Therefore, the court held they owe a duty of supervision to each student. If they entrust a student to a teacher they know is a threat, they have violated that duty.
Wow. So rank matters. The higher up you are, the more duty you hold. It creates a hierarchy of liability.
It does.
What about the third element, foreseeability and knowledge? You mentioned knew or should have known. How do they measure that? Is it just a vibe the judge gets?
It's more concrete than a vibe, but it is broad. The rule is that liability attaches if the supervision is unreasonable in light of foreseeable risks.
And how do they apply that? What's the standard?
The application here sets a specific standard. It's not just actual knowledge, meaning you saw the abuse happen with your own eyes. It also includes learning of facts that would lead a reasonable person to conclude a student is being abused.
The constructive knowledge standard.
That's it. Think about it. If you see a teacher constantly taking a student to a back room, or buying them expensive gifts, or acting weirdly possessive, those are facts. If a reasonable person would look at that and say something is wrong, then you are on the hook.
So you can't just play dumb.
We can't just close your eyes and say, well, I didn't see the assault, so I didn't know.
That is a powerful standard. Finally, the fourth element. This is the one about the scope and location of the injury. You mentioned the complaints didn't say where the abuse happened. What if the abuse happened off campus? Does the school's duty end at the school gate at 3:00 p.m.?
This is often the most contested point in these cases. The general rule is that the duty exists only when parental protection is compromised. So, essentially, during school hours. However, the application is nuanced. The court held that if a negligent failure to supervise during school hours is the proximate cause of an injury that occurs later, the employee can still be liable.
Proximate cause is a very lawyerly term. Can you translate that?
Think of it like a row of dominoes. If a teacher grooms a student in class-passing notes, building that secret relationship, isolating them, that's the first domino.
Happening on school time.
That's happening on school time. If the principal ignores those red flags, the principal has breached their duty at school. Now, let's say the grooming works. The student trusts the teacher, and that leads to an assault on the weekend at the teacher's house. That assault is the last domino falling.
So the principal is liable for the last domino even though it fell on a Sunday?
Yes. The principal's failure to stop the grooming is the proximate cause of the assault. Even though the final injury happened off campus, the negligence happened on campus. So the court concluded that this is a question for the jury. You can't just dismiss the case because the assault happened on a Saturday.
That is a crucial distinction. It connects the dots between the negligence and the harm. And after analyzing all these elements, what was the court's final conclusion?
The court remanded the cases.
Remanded.
It means they sent it back to the lower court for trial. They essentially said, we can't decide this on a motion to dismiss. We can't just throw it out.
So the lawsuit moves forward.
It moves forward. Some employees owe a duty, specifically the supervisors, principals, and superintendents, while others, like non-supervisory staff, do not. The plaintiffs can proceed, but they have to prove that the specific defendants they are suing had that supervisory authority and had the requisite knowledge.
Okay, that is a lot of legal machinery. I want to make sure this really sticks for you. Let's move to some scenarios. I want to test the edges of this supervisory responsibility and this off-campus rule because I feel like there are some gray areas here.
Let's do it. Visceral examples are the best way to lock this in.
Scenario 1. Let's go back to the janitor distinction because that still bothers me. Let's say a school janitor is cleaning the hallway and looks into a classroom. He sees a teacher acting weirdly, maybe intimately touching a student's shoulder way too close. He thinks that's not right, but he finishes mopping and goes home. He never tells anyone. Later, it turns out that teacher was abusing the student. Is the janitor liable? Really?
Under Marquay, likely not. And here is why you have to separate the moral from the legal. The janitor is not a parental proxy. The parents didn't entrust the education and custody of their child to the janitor.
He doesn't have supervisory responsibility.
Exactly. He gets a paycheck from the district, yes, but he hasn't stepped into the shoes of the parent. His duty is to the building, not the child's upbringing.
Okay, so let's flip it. Same scenario, but instead of the janitor, it's the vice principal walking down the hall. She sees the same thing. She keeps walking because she's busy.
Total game changer. Instant liability. The vice principal is a supervisor. She is a parental proxy. She has overarching custody. By seeing that red flag facts that would lead a reasonable person to suspect something and walking away, she has breached her duty.
So the difference isn't what they saw.
The difference is their role in the school's hierarchy. The vice principal has the power to intervene, so she has the duty to intervene.
That is crystal clear, even if it feels harsh for the janitor to get a pass. Okay, scenario 2. The off-campus loophole. Let's make this one tricky.
Go for it.
A math teacher is grooming a student. In class, he's just really nice, maybe gives her a ride home once or twice. The principal hears rumors about the rides but ignores them because the math teacher is a good guy and has been there for 20 years. Nothing bad happens on school grounds.
A classic setup.
But then, on a Sunday, the teacher invites the student to his house, and that is where the sexual assault happens. Can the principal say, hey, that happened on a Sunday, not my problem?
No, he cannot. And this is the sticky mental image you need. Imagine the grooming is like lighting a fuse. The fuse is lit in the classroom when the principal ignores the rumors about the rides.
That's the negligence.
That's the breach of duty. The explosion happens on Sunday at the teacher's house. The principal is liable for the explosion because he let the fuse burn during school hours. The negligence set the chain of events in motion.
So you can't separate the grooming from the assault?
You can't. If the school had done its job on Tuesday, the assault wouldn't have happened on Sunday.
That is a terrifying but necessary logic. If you ignore the smoke, you are responsible for the fire, even if the fire burns down a house down the street.
Precisely. It closes the loophole that would allow schools to wash their hands of abuse just because the predator was smart enough to move the final act off premises.
So what does this all mean? If you're a lawyer or a law student or just someone trying to understand liability, how do you synthesize this? We've covered a lot of ground.
You need a diagnostic checklist. If you're ever looking at a school liability question or writing an exam on this, you follow these 4 steps derived from Marquay. This is your roadmap.
Walk us through it.
Step 1.
Yeah.
Check for the special relationship. Is the victim a student? Is the institution a school with compulsory attendance or custody? If yes, the door is open.
Okay, simple enough.
Step 2. Verify the defendant's status. You have to look at the specific person being sued. Do they have supervisory responsibility? Are they a parental proxy? If it's a teacher or coach, yes. If it's a principal or superintendent, yes.
And if it's non-supervisory staff?
Like a secretary or janitor, likely no duty. You have to filter out the wrong defendants here.
Got it. Filter by role. Step 3.
Step 3. Analyze knowledge. Did the defendant have actual knowledge?
Oh.
Or, and this is the big one, did they have constructive knowledge? Did they know facts that would make a reasonable person act? If they ignored red flags, this element is met.
You don't need a signed confession.
Not at all. And the final step, 4. Determine proximate cause. Did the failure to supervise during the custodial period during the school day cause the injury? Even if the final injury occurred outside the school environment, if the breach happened inside, you have a case.
That is a powerful framework. It really highlights that while schools replace parents during the day, that transfer of power comes with an incredibly heavy legal burden.
But the court seems to say, you ask for the control, you get the responsibility.
That is exactly right.
The court is balancing 2 things here. On one side, the inconvenience to the school of having this extended liability. It's hard to police everyone, it's expensive, it's difficult. But on the other side is the social importance of protecting children. The court states clearly, the interest of the child outweighs the inconvenience to the school.
It's a sobering reminder. We trust schools with our most valuable people. The law says that trust isn't just a nice sentiment, it's an enforceable contract.
And if we connect this to the bigger picture, this case really reinforces the idea that silence is not a shield. In a position of authority, looking the other way is an active choice, and it's a choice that can have legal consequences.
Here is a provocative thought to leave you with. Marquay relies heavily on the idea of compulsory attendance. The state forces you to be there, so they must protect you. But we live in a changing world.
Right.
What happens to this special relationship when education becomes less about physical custody? What about online learning? What about homeschooling co-ops, where attendance is voluntary, but the power dynamic still exists? Does the duty evaporate if the student isn't physically trapped in the building?
That is a fascinating frontier. If the custody isn't physical, does the duty remain? That is exactly what the next generation of lawyers is going to have to figure out.
Something to mull over. Thanks for diving in with us.
Always a pleasure.
We'll see you on the next deep dive. Stay curious and stay safe.